You are our second argument on February 17th, 2022. As you can see, the panel is Judge Hensel, Judge Sutton, and myself, Judge Teodosio. I'll be presiding this morning. And the case we are about to hear arguments on is case number 21CA011713, Banks versus Edmundson. Each party will have 15 minutes to present your argument. The appellant may reserve up to 5 minutes, for rebuttal. I'll be keeping track of time. So Attorney Goldberg, if you want to reserve time, let me know at the start of your argument, and I'll let you know as you get close to that rebuttal time. We have a rule, of course, that we're not to use victims' names or children's names. So if that applies to your case, please just refer to them in a general sense, initials or some other way. We have read the briefs and we are prepared to proceed if you are. So let me start by asking Attorney Goldberg, would you like to reserve some time?
Yes, Your Honor. 4 minutes, please.
4 minutes. And I will let you know as you get close to that. Let me set my clock and then I'll have you get started. 1 second here. All right, whenever you're ready.
Thank you, Your Honor. Excuse me. May it please the court, my name is J. Michael Goldberg. I have the privilege of representing the plaintiff appellant Chris Banks in this case. May I dispense with the recitation of the facts?
You may.
Thank you, Your Honor. I believe that this is an issue of first impression, that issue being the application of revised code 23-1519C in terms of supplying the standard of review for an appeal of a judgment on the verdict amount where the award is claimed to be inadequate. I think I was able to find one other case that cited that statute for the standard of review, but it dealt with an appeal based on the award being excessive. So, and I think that it was a pretty comprehensive brief. It was not easy to get that done in 30 pages, but I got as much as I could in there. But I thought, arguing to this panel, if I were sitting up there, what questions would I have? And I came up with 4 questions that I'd have for me. And the first would be, counsel, why didn't you just file this as an appeal of the verdict being against the manifest weight of the evidence? The second question would be, if both an appeal on verdict against the manifest weight of the evidence and this appeal based on the statute are both de novo reviews, what's the difference if the review, if you review it and remand it for a new trial on the issue of damages? And the third question would be, am I appealing only the award for future permanent non-economic damages, or am I appealing the entire damage award? And of course, there would probably be a subpart to that, which would be, why would the so-called past damages be inadequate? Personally, if I were on the bench, I would think that that last question is the most important for our purposes. I invite you to interrupt me anytime with any questions. In terms of appealing the amount and the award being the future and permanent award of $3,500 for the next 32 years being inadequate, I think that was laid out with some significant detail in the brief. But I think I would just say one thing. It's 1.25 cents per hour. That's what it breaks down to. $2.10 a week. Now, $2.10 won't buy you a gallon of whole milk at Giant Eagle. It won't allow Mr. Banks to fill up his gas tank. It will allow him enough gasoline to make most of the first trip to his work at the VA in Wade Oval from Malaria. He wouldn't even make it the entire way. The $109 that breaks out to for a year would allow him a few trips back and forth to his job, and that's it. And the point is, this is not, there's no how much is adequate. And I think I put this in the brief. You don't have to decide what's an adequate amount. You just have to look at this and you have to say, this is wrong. Okay? There doesn't have to be a bright line test. It would be based on the totality of the circumstances in any given case. And in this case, with 32 years of statistical expected life. Now, most people are living beyond the statistical lives that are produced in these tables. This one happened to be by the CDC. But 32 years, that's a shockingly low amount. And it's not even a matter of what can I do with that money? What could Chris do with that money? That is not the point. And in fact, at trial, when opposing counsel said to the jury in closing argument, that's a lot of money. That's more money. The demand that I made on my closing argument, the demand I made is more money than a lot of people in Lorain County make over their lifetime. And I felt that I needed to address that. And the point is, it doesn't matter how much he's going to get. It doesn't matter what he's going to do with that money. That's completely irrelevant. It's no more relevant than if somebody gets money for property damage for their car and decides I'm not going to fix it. They don't have to repair it with the money that's given to them to repair. It's nobody's business, and it's completely irrelevant and immaterial to the jury's deliberations. So the question is, how do you determine the value? How do you determine what is inadequate? Well, you look at this and you have to look at what was taken from him. He was slammed into from behind and he injured his cervical spine. People say, oh, he hurt his neck. He had whiplash. Well, whiplash is a mechanism of injury, and he hurt his spine. It's depending on how you look at it. The spine is divided into either 3 sections or 4 if you count the sacrum. There are 7 vertebrae and cervical discs, and he had no arthritis. He had no degenerative disc disease before that crash. And Dr. Smokovich testified, and he was the only expert to testify. And as a matter of fact, the defense didn't put on a single witness, not one. He was the only one to testify that Chris would, throughout his future, have accelerated arthritic changes in his neck. He does not have arthritis, or didn't have arthritis before this. And what did that translate to? It translated to lack of stability of the head, because the cervical spine supports the head. It allows us to extend and look back, flex and look forward, rotate and tilt. And for the rest of his life, he is likely, more likely than not, to have problems with that. And it's never going to go away. And there's a lawyer who's famous in the country who talks about pilot light pain. And if anybody here knows what a pilot light is, it's a little flame that, when you light the gas, it will allow the furnace to run, or the water heater. And it's not a big flame. It won't burn you unless you put your finger on it, but it's not going to be anything debilitating. But it's there. It's always there, all the time. And more likely than not, according to Dr. Smokovich, Chris is going to have this pain. Now, is it going to be debilitating? Is it going to keep him from doing things? Probably not. But it's going to change the experience that he has in doing those things. Okay? He'll have to think twice before he plays basketball, because he knows, yeah, I can play, but I'm going to play in pain. Or I'm going to play, but afterwards I'm going to pay for it, one way or the other. And we've all woken up. We've all had stiff necks. We've all had sore necks and headaches and things like that. But, you wake up in the morning and you have a stiff neck, like, oh, my neck is stiff. And it's not just the neck. You cannot isolate that part of your body. It is it affects your whole persona. It affects how you affect other people. Okay. You go into work and your neck's bothering you and you've got a headache from it and you're in a bad mood. And people around you relate, they feel that now. They're empathizing. And but you wake up with that and you're like, God, I hope this goes away. And the next morning you wake up with it again. You're like, oh, when's this going to go away? And by the third morning, it's gone. Hallelujah. I don't have this neck pain anymore. Well, that's not Chris. Okay. Chris doesn't have that hallelujah moment. Chris just knows that his neck is going to constantly hurt and the pain will change. He'll go up and down. He might be on a 2 out of 10 this day and a 5 or 6 the next day, but it's always going to be there. He's going to have headaches that he otherwise wouldn't have had. And so this de minimis award, and by the way, I don't think the jury, I don't think there was I think they tried to do the right thing. I mean, they found permanency. And that's another thing that makes this case different than pretty much any other that's on the books. Because,
Mr. Goldberg,
Yes.
Goldberg, I hate to interrupt you. I appreciate your argument, but I wanted to get back to that first point that you raised about the application of revised code 2315.19 and the standard of review that you say is at issue in this case. At the trial court level, was the motion made pursuant to 2315.19, or was it made under? Okay.
And it wouldn't be, because 2315.19C imposes a duty on the appellate court. That's a statute that imposes a duty on the reviewing court. It has nothing to do with the trial court. The trial court has its own jurisdiction, its power and authority to look at a verdict, and they do this all the time. They'll get a Rule 59 motion, that says, where the defense will say, this is an excessive verdict, and the court will reduce that verdict. And that's all they'll do. They'll reduce it. Now, unfortunately, you can't do that when you're claiming an inadequate verdict. The court just can't say, okay, I'm going to increase this award. That invades the province of the jury. So what they have to do is they say, okay, I'm either going to grant the new trial or I'll grant an additor, but everybody has to agree to the additor. And
Attorney Goldberg, you are at the 11-minute mark, so you're welcome to continue, but you'll be eating into your rebuttal time, just to let you know.
I just want to make sure that I answered your question, Judge Sutton. And if you have no other questions, then I'd be happy to go ahead and continue after.
Okay. Thank you. I'm good.
Okay, you'll have 4 minutes for your rebuttal. Now, Attorney Pearson, let me reset the clock. You've got 15 minutes, sir.
Thank you. May it please the court, I appreciate the opportunity to present in front of this court. It's not every day that I get a chance to argue in front of the Court of Appeals, and most of the time we don't really want to be here. So I acknowledge that before I start my argument, but let me start by just stating that the trial court did not err in denying appellant's motion for a new trial pursuant to Civil Rule 59A6. And I state that to indicate that that is the basis for us being in front of this court today. The motion, as Mr. Goldberg indicated, was made under Civil Rule 59A6. And I'll talk about that analysis in a moment, but I want to talk about something else before I get to that point. 2315.19, which Judge Sutton just a moment ago inquired about, was not the appropriate statute to bring this action in front of the court. Mr. Goldberg does that in order to access the de novo standard of appeal. That's the only reason. And there are two issues before this court as it relates to 2315.19. First of all, he tells this court that that could not have been made, that he couldn't have brought this motion for a new trial under that section. A reading of 2315.19, the very first sentence in Section A states as follows: upon a post-judgment motion, a trial court in a tort action shall review the evidence supporting an award of compensatory damages. So Mr. Goldberg is absolutely wrong. The trial court had the right And he had the right, he could have and should have brought that argument at the trial court level. And the fact that he's bringing it now makes this court's job very easy. He didn't argue that at the trial court level and has no right to argue that at this time. So this court can move on and deny the appeal simply on that basis. But if we look a little further into 23-15-19, it goes on to say, a trial court in a tort action shall review the evidence supporting an award of compensatory damages for non-economic loss that the defendant has challenged as excessive. It says nothing about the plaintiff. Clearly, Mr. Banks in this case was the plaintiff. That is a statute that was created by Senate Bill 80 during tort reform to allow for defendants to challenge verdicts that were excessive at the trial court level, not at the appellate court level. So Mr. Goldberg is just incorrect in his claim that he can bring this appeal under that section in front of this court on a de novo standard. That is incorrect. He had two options. He brought this appeal to this court as a result of a motion for new trial that he filed, as I indicated before, under Civil Rule 59A6. He had several options by which to bring his motion to the trial court for a new trial. He could have filed it under Civil Rule 59A4, which speaks to excessive or inadequate damages appearing to have been given under the influence of passion or prejudice. He did not. He only filed it under Civil Rule 59A6. As this court knows, that section reads, the judgment is not sustained by the weight of the evidence. When you file a motion for new trial under that section, the standard of review for this court is abuse of discretion. So even though Mr. Goldberg didn't argue that in his appeal, I'm going to now analyze that before this court. In order to find an abuse of discretion, this court has to determine that a trial court acted unreasonably or unconscionably in coming to its decision to deny the motion for a new trial. There has to be more than an error in judgment or a mistake of law. The trial court should not reverse a judgment as being against the manifest weight of the evidence when it is supported by some competent, credible evidence, going to all essential elements of the case. A motion for new trial should be granted when it appears that the jury failed to consider an element of damages established by uncontroverted expert testimony. However, a trial court must abstain from disturbing the verdict unless it determines that the jury's assessment was so overwhelmingly disproportionate as to shock reasonable sensibilities. I want to talk to you a little bit about the testimony that was provided in this case. Mr. Goldberg is correct. Defendant didn't present any witnesses in its defense of this case. It wasn't obligated to. But what Ms. Perez did do at the trial court level was cross-examine each of the witnesses presented by counsel. Starting with Dr. Fite. Dr. Fite testified that Mr. Banks received 6 weeks of chiropractic treatment for a soft tissue injury that was suffered in the October 31st, 2017 accident. He treated Mr. Banks from November 7th of 2017 to December 20th of 2017, 6 weeks of chiropractic treatment. Dr. Fite was the only treating doctor involved in this case. He did not issue any opinion on permanency whatsoever. He only indicated that at the conclusion of his treatment for Mr. Banks, or of Mr. Banks, that he was pain-free. He had no other problems, never came back to him. And the record will indicate, and the testimony indicated, that Mr. Banks had no other treatment from December 20th, 2017 up until the date of the trial. There were several inconsistencies during the course of Mr. Banks' testimony that were brought out by Ms. Perez during her cross-examination. Initially, Mr. Banks claimed on direct examination that he had limitations as a result of the injury suffered in this accident to his neck. But on cross-examination, he admitted to Ms. Perez and in front of the jury that he testified at his deposition that there was nothing that he was unable to do as a result of the neck injury suffered in this case. Another inconsistency. As the court is aware, there had been an accident with the deer in April of 2018. In his testimony on direct examination, he testified that he did not suffer any injury whatsoever in that accident with the deer. His testimony was as follows: "My pride was hurt, but other than that, I didn't really feel any pain from that." On cross-examination, Ms. Perez presented him with the emergency room record and indicated that in that record, he indicated to the emergency room that he had pain in his neck, both ankles, both wrists, and his right knee. And at that time, excuse me, was diagnosed with a strain of his neck. Asked to Dr. Simkovich, Dr. Simkovich did not see Mr. Banks until a year and a half after this accident. Ms. Perez pointed out on cross-examination that Dr. Simkovich was being paid to testify in front of the trial. Dr. Simkovich did not render any treatment whatsoever in this accident. All that he was hired for was to opine on permanency. That was the only testimony that he provided. During the trial, he acknowledged that the October 31st, 2017 accident was consistent with what is called an inertial injury, as was the April 2018 motor vehicle accident with the deer. On cross-examination, he indicated as follows. Ms. Perez asked him, "So isn't it fair to say that the collision with the deer at 60 miles per hour, that for Mr. Banks was significant enough to go get treatment and mark a diagnosis of strain of the musculature of the neck be another factor that could explain his injuries when he presented to you on April of 2019? He answered, "For muscle strain, yes." Question: "But you don't make a distinction in your report between a muscle strain and a ligament strain." Answer: "No." On page 5 of your report, you indicate that the accident on October 31st, 2017, the injury was consistent with an inertial injury to the cervical spine. Answer: "Yes." Hitting a deer at 60 miles per hour is also an inertial injury, correct? Answer: "Yes." I bring those up to indicate that there was evidence presented to the jury by which it was able to arrive at the verdict that it arrived at. And although it may not have been something that was satisfactory to Mr. Banks and or counsel, it is the jury's verdict. We all know, this court as well, that a determination of an award is within the province of a jury. The assessment of damages is so thoroughly within the jury's province that a reviewing court is not at liberty to disturb it absent a finding of passion, prejudice, or that the award is manifestly excessive. We don't have that here. A jury is free to believe all, part, or none of the testimony of the witnesses presented to it. And although the defendant did not provide any witnesses, she cross-examined the witnesses of the plaintiff that the plaintiff presented, and the jury was free to believe what they wanted to believe about what those witnesses testified to.
Well, the jury did find they did award damages for permanent non-economic damages, correct? That's a $3,500.
They did. They did.
And that was based on testimony from the doctors.
It was based on all the testimony, Your Honor. The doctor, the chiropractor, and the plaintiff. But we have to assume that because we don't know how the jury came to their conclusion. We just know that the conclusion they came to was that they awarded permanency and thought that the permanency was worth $3,500. There is no basis to refute that finding. And although counsel wants to present to this body that if you break that down, that's pennies, well, the jury may not have believed much about this injury at the time. They may not have believed that although it was a permanent strain, that it was going to cause Mr. Banks much problems in the future. Clearly, that's what their verdict demonstrated.
Thank you.
There's case law to support that, by the way. The mere size of a verdict is insufficient to establish proof of passion or prejudice, but that is under Civil Rule 59A4. And I raise that because Mr. Goldberg had the right to bring that claim at the trial court level. He chose to bring his claim under Civil Rule 59A6. That is the rule that the trial court rendered their decision. They made a decision based only on that section, not on Civil Rule 59A4, nor 231519. Those were not raised at the trial court level and should not be entertained here by this panel. I want to end by saying that there was clearly competent and credible evidence presented by this jury by which it rendered its verdict. The trial court, and that's the standard that we're here in front of this court, the trial court did not abuse its discretion in denying the motion for a new trial. There's one other thing I want to point out, and this was not in the record, but Mr. Goldberg chose a strategy decision on his part not to offer any evidence on economic damages. So the jury's verdict was only about non-economic damages, pain and suffering, which they thought were related to this accident. And clearly that is within the province of the jury to come to that conclusion, the conclusion which they did in this case. And there is no basis to overturn that.
Thank you, Mr. Pearson. You do have a little time left, so let me see if Judge Hensel or Judge Sutton, any questions? No? No? All right, thank you for that argument. Attorney Goldberg, you have 4 minutes left for your rebuttal, and you may begin when you're ready.
Thank you, Your Honor. Wow, that just is packed. So the first thing that Mr. Pearson said was the trial court did not err in denying the Rule 59 motion. Who cares? Under Easley versus Volkman, a Rule 59 motion is irrelevant to an appeal. And incidentally, an appeal based on the verdict being against manifest weight of the evidence, this is not an appeal based on that, but if it were, the standard of review in that appeal would be de novo. So there's no getting around the de novo review. If I were attacking the trial court's ruling on the Rule 59 motion, then sure, we might be talking abuse of discretion. But Rule 59 isn't mentioned in the appellate brief. It's not part of this appeal. And just like a plaintiff establishes the parameters of a lawsuit by setting forth in the complaint the causes of action that he or she chooses, that's the roadmap for the court, all the way up to when the jury is charged by the court. The appeal is no different. We lay out an assignment of error, and that sets the parameters for this appeal. So while appellant appealed based on the judgment on the amount of the award, with the standard of review being arising out of RC 231519C, here they're coming and arguing, well, you know what? I don't care what he argued. And I can't help it. It's like he's going to a Browns game expecting to play tennis, and he's upset because nobody put up a net for him. And it's ridiculous. The entire appellate brief that was filed by appellee has nothing to do with this appeal. They just abandon it. They mentioned 231519C in a footnote one time. Beyond that, so the statute provides for a de novo review, as does a manifest weight of the evidence appeal. Next, Mr. Pearson mentioned that plaintiff appellant had the opportunity to raise the statute at the trial court level. That is not accurate. 231519A deals strictly with an excess verdict, a claim where the defendant has challenged the verdict as excessive. It's right. That's the wording of the statute. It's right there.
So what is the rule of law you'd like to see coming out of this case?
The rule of law, and I actually laid out a proposition of law in there, and the rule of law is that when an appeal is made based on the verdict being inadequate, then the court is to independently review the facts, weigh it, and the law, and then apply its judgment as the 13th or 9th juror, except you don't even have to get into the attacking the province of the jury. This Division C of the statute applies. It's just the judgment on the amount. You don't have to overturn the jury. Maybe that's the practical import of the effect of it, but it's not the same as, being the 13th juror or 9th juror on a civil case, and weighing the evidence and saying, you know what, we disagree with the jury, or they just got it wrong. The jury got it right here. They found permanency. They in a jury interrogatory, in a special rog, they gave permanency. Okay, they just didn't understand, or they lost their way. They lost their way, and it's up to this court to get them back on path. Not this same jury, obviously, but a remand with a new trial on damages. On
Attorney
both.
Goldberg, you
Yes, sir.
are at your 4-minute mark, so
Okay.
I'll let you wrap up if you want to just have a closing sentence.
That's a lot of pressure. So
A very short closing sentence.
the deer accident, Stinson versus England doesn't go
Oh,
away.
I'm not going to hear no more argument. I'm saying,
Oh,
you just want to
okay.
get to what you want us to do.
Oh, thank you, Your Honor. No,
Okay.
So I would, on behalf of appellant, we asked this honorable court to reverse the judgment and remand the case for new trial on all non-economic damages, on the
Right.
amount of those damages.
Gentlemen, thank you for your arguments here today on behalf of Judge Sutton and Judge Hensel. We really do appreciate you appearing by Zoom and taking the time to do that. We will take the matter under advisement, issue a decision in due course. Both of you will receive a copy of the decision on the day it's released, and the opinions, as you probably know, are also posted on the Supreme Court of Ohio's website. This was our last argument set for today, so the court will be adjourned until it reconvenes on February 22nd. Thank you again for your appearance here, and you both have a good day.
Thank you, Your Honor.